DM. Mr. Holl is here today after failing to appear before this court on July 13th, 2022. Bond is currently set at $500. This is the fourth bench warrant. He reports no employment. Last payment made on this account was in July of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on November 15th, 2023 at 8:00 a.m. before this court.
Mr. Hollett, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on November 15, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Your Honor, now I had moved to right over here on South Avenue. I don't know if you're familiar.
What happens when you move?
Okay, so I've been walking right.
When you move, you have to notify the front of the court in writing that you move, or otherwise they'll just send it to your old address, which is probably what happened. So when you get out of jail this time, make sure you go down to the front of the court's office and fill out the form for change of address, or they'll just keep sending it all to your old address. Okay, are you able to post a bond, sir?
Oh, it depends on what it is.
Okay.
I'm a family.
Okay, well, court does note that you haven't paid in well over a year, so I'm taking that into consideration, but it is your fourth bench warrant, so I'm looking at that as well. What I'm going to do is I am going to reduce your bond in hopes that you could be released pending here. I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, I don't.
Okay, thank you, sir. You're free to go. Have a good
Motley
day.
is here today after failing to appear before this court on October 25th, 2023. Bond is currently set at $1,766. This is the second bench warrant. He reports that he is employed at Tenneco. Last payment made on this account was in August of 2023. That was a $200 bond forfeiture. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on November 15th, 2023 at 8:00 a.m. before this court.
Mr. Motley, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on November 15, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
It all depends on what it is.
Okay. Well, how much do you have to be able to post a bond? Do you know?
I got like $100 on me right now in my account.
Okay. Well, unfortunately, it's again, your arrearage is substantially very high.
Okay, but I've been sending money to my baby mama on Cash App because I don't know how.
You can't do that. You got to send. You've got to
Okay.
You've got to pay it into the state so that they have a record.
So I never knew how to do that because it always came out of my check.
Well, what's happened with Tenneco that it's not coming out of your check?
Well, I'm currently unemployed right now.
Oh, okay. Well, what I'm going to do is I am going to reduce your bond. It's right now, it's just about $1,800. I'm going to reduce it to $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay. Thank you, sir. You're free to go. Have a good day. I guess he lost his job, Mr. Chapman, between the time you stated that and the time I mentioned it.
687 DS.
Okay.
Mr. Harvey is here today after failing to appear before referee Snyder on August 22nd, 2023. Bond is currently set at $500. This is the third bench warrant. He reports no employment. Last payment made on this account was in April of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on November 15th, 2023 at 8:00 a.m. before this court.
Mr. Harvey, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 15, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm homeless right now. I have no employment, and I got some court cases I got to take care of also in another county.
Okay.
So I'm going to be here. I'm going to be here and there for at least probably the next year.
Okay. Well, I'm gonna reduce your bond in any event in hopes that you could be released. I'm gonna set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
I was wondering if I could get that down to nothing, because I can't leave this county and get the other counties taken care of until I have
this county or that county will communicate with this county, because that happens all the time. So I'm not going to release you just so that you can go on these other matters.
Okay.
Thank you. You're free to go.
134 DS. Ms. Odum is here today after failing to appear before this court on November 1st, 2023. Bond is currently set at $1,547. This is the 8th bench warrant. She reports no employment. The last payment made on this account was in July of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on November 15th, 2023 at 8:00 a.m. before this court.
Ms. Odum, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 15, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
I'm not sure.
Okay. Well, the court does note it is your 8th bench warrant, and again, so the court is taking that into consideration, and you do have a sizable arrearage. What the court's going to do is I am going to reduce your bond, though, in the event that you can be released. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
I don't know. I don't. Well, I do, because when I signed some papers today, I think it was the debt officer, he had mentioned something about on my paperwork about my address. There's no address for my drive. There's no apartment. He's mentioned something about apartment 3. There's no apartment.
Okay. Okay. Well, that's fine. It should, if we have that address, it should be going to that address then.
No, because I haven't received nothing.
Okay.
Nothing from no one.
Okay. Well, we'll check that out and find out on the November 15th date to speak to the enforcement officer to find out what address it went to and what they have on file. So, okay. Thank you, ma'am. You're free to go.
Thank you.
Thank you, Your Honor. I have nothing more.
Anderson for plaintiff.
Thank you. Court will note that this matter is before the court on the plaintiff's notice for entry of judgment of divorce. In this matter, I guess I'll ask Mr. Reed, just to clarify, are you disputing or contesting anything in this case?
No.
Okay. Go ahead, Ms. Henderson.
Thank you. Good morning, Ms. Reed. Could you please state your full name and spell your last name for the record?
Jenny Michael Reed, R-E-E-D.
Thank you. Did you consult the law office of Mumford, Shubel, McFarland, and Barnett regarding filing for a divorce in about April of 2023?
Yes.
And did we prepare complaint for divorce and all other documents to initiate the process on your behalf?
Yes.
Have you in fact signed a complaint for divorce prior to filing it?
Yes.
At the time of filing, have you resided in Calhoun County for 10 days and the state of Michigan for 180 days?
Yes.
At the time of signing the complaint, were all allegations therein true to the best of your knowledge and belief?
Yes.
Do they still remain true today?
Yes.
Are you currently pregnant?
No.
In the complaint, you allege that there has been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage could be preserved. Could you please briefly state to the court the reason for the breakdown of your marriage?
Financial strain, as well as the stress of our son going through cancer treatment during COVID, it was too much for our relationship.
If the judge were not to sign the judgment, is there any reasonable likelihood that you and Mr. Reed would go back to living as husband and wife?
No.
And we have started this process by a consent order. And now we have applied for a default and are presenting default judgment. Have you had a chance to review that judgment?
Yes.
Do you believe that the provisions regarding child-related issues in it are in the best interest of your children?
Yes.
And do you believe that there is a property settlement that is fair for both you and Mr. Reed?
Yeah. Yes.
Are you asking that the court sign this judgment?
Yes, please.
Thank you. I don't have any further questions. May it please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will enter the judgment as submitted in this matter on the UCSO. That will conclude your case. You will be divorced. Best of luck to both of you. I hope everything works out for you, and the court will end this hearing at 8:46 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Good morning to everyone.
Thank you.
Morning.
I'll start with you first, Mr. Garen. In this matter, there's been a consent judgment that's been submitted, means that you've signed that. Did you in fact sign that agreement?
Yes, I did, sir.
And so you're not disputing, you're not contesting anything, correct?
No, sir.
Okay, go ahead when you're ready, Ms. Podolsky.
Thank you. Elizabeth, can you hear me okay?
Yes, I can.
Okay. Do you recall coming to my office in May of 2023 and signing a complaint for divorce?
Yes, I do.
And in that complaint for divorce, you stated you'd been a resident of the state of Michigan for at least 180 days and a resident of Calhoun County for at least 10 days. Was that true when you signed the complaint?
Yes, it was.
And in your complaint, you also stated there'd been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood your marriage could be preserved. Was that true when you signed the complaint?
Yes, it was.
Does that remain true today?
Yes, it does.
And you and your husband have one minor child together, is that correct?
Correct.
Are you currently pregnant at this time?
No.
Have you had an opportunity to review the judgment of divorce?
Yes.
And do you agree with the provisions as they relate to custody, parenting time, and child support?
Yes, I do.
And have you reviewed the provisions as they relate to the matters involving property and debt?
Yes.
And do you agree with all provisions contained within the judgment?
Yes.
Is it correct that neither you nor your husband are seeking spousal support?
That's correct.
And do you understand that your judgment provides that neither one of you can come back to the court and seek spousal support in the future?
Yes.
If for some reason the judge were not to sign the judgment, do you believe there's any chance at reconciliation with your husband?
No.
Thank you. May it please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs. It cannot enter that judgment until tomorrow, but we have it. We will enter it at that time. That will conclude your case. You will be divorced, and best of luck to both of you. I hope everything works out, and you're free to go, and we'll end this matter at 8:49 a.m. Have a good day.
Thank you.
Thank you.
Oh, okay.
I'm here.
Just want to make sure that he is unmuted before
You
we.
are? You have to unmute.
I do.
Okay.
Attorney Wesley Todd for plaintiff.
Okay, I'll go to you first, Mr. King. You have signed a consent judgment of divorce in this matter. So is that correct?
Yes, that's correct.
So you're not disputing and you're not contesting anything?
Not disputed, not contesting anything.
Okay, thank you. Go ahead, Mr. Todd.
Thank you, Your Honor. Ms. King, do you remember signing a complaint for divorce?
Yes.
At the time you signed that complaint, were all those allegations true, and do all those allegations remain true today?
Yes.
Did you live in this county for at least 10 days in the state of Michigan for at least 180 days prior to filing the complaint?
I'm sorry, what?
Did you live in this state for at least
Yes.
108 and the county for at least 10 days before filing the complaint?
Yes.
Have you had an opportunity to review the proposed judgment and believe it is equitable?
Yes.
Are you currently pregnant?
No.
Have you had an opportunity to review the custody, parenting time, and child support provisions and believe they are in your children's best interest?
Yes.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Correct.
Would you briefly describe for the court why that is?
Just we're done. I'm not really sure exactly. Like the marriage cannot be saved.
Nothing further, Your Honor.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will sign the consent judgment the UCSO submitted in this matter. That will conclude your case. You will be divorced. Best of luck to both of you. I hope everything works out. Court will end this matter at 8:53 a.m. You're free to go. Have a good day. Court will note the appearance of Ms. Podolsky on behalf of the defendant. This matter is before the court on the defendant's motion regarding counseling and other relief. This matter was adjourned from 2 weeks ago at the request of the plaintiff. In this case, Ms. Podolsky.
Thank you, Your Honor. As we've stated in our motion that there has been some significant issues occurring that are requiring the use of our family wizard and for the plaintiff father to engage in counseling with the minor child. First, the plaintiff father routinely calls my client's place of employment with harassing phone calls. He has a history of harassing her, swearing at her, and verbally attacking her. On June 30th of this year, my client reached out to him after receiving a call from the school principal stating that he had been screaming at her and calling her a racial slur. Unfortunately, the communication between these parties because of plaintiff's behavior has been less than ideal. So we do believe that our family wizard would be appropriate in this case, and we'd ask the court to order the parties to communicate using solely our family wizard. Further, we do believe that there is a need for counseling between the plaintiff and the minor child. The minor child is already in counseling. He does have severe anxiety about attending parenting time at plaintiff's home. This is manifesting physically in stomach issues, GI issues. He reports not being able to do his homework. This is evidenced by it being not sent back home with him after parenting time. As recently as last week, the minor child had to miss recess at school because he had not completed his homework at dad's house. When he is trying to do it there, he does not receive assistance. If he's getting frustrated and upset, he's called soft and emotional. Unfortunately, the plaintiff in this matter has talked to the minor child about this motion, both verbally and in writing. He has stated that the minor child won't be coming to parenting time anymore, and this is the last time you'll ever see me, but then reverses that and changes his mind. It has come to the attention of my client that the plaintiff and his other family members in the home have been reading the minor child's journal. This is not appropriate behavior. The interactions have been inappropriate. The lashing out at the minor child, not allowing him to have his cell phone for the ability to communicate with the mother, is just causing the minor child to become increasingly more anxious about parenting time. And as I stated, is manifesting physically. We do believe that it would be important for the plaintiff father to engage in counseling with the minor child. He has a counselor already. And we'd ask that he be ordered to engage in that counseling in addition to using the Our Family Wizard for communication with my client. And we'd also ask the court to order that the minor child be allowed to have his phone to be able to contact the parent that he is not with. Thank you.
Okay, thank you. Mr. Irons, what's your response?
Your Honor, I have one question first, if I'm allowed to.
Well, you can ask any question. Doesn't mean we'll answer it, but you can ask.
Okay, so I have a question for the attorney that just spoke. She mentioned that I called Abigail's job multiple times, harassing her. I would like to know what number did I call?
Okay, well, she doesn't have to answer that, sir.
Well, the number I called, Your Honor, was 911. And the only reason I called 911 is because a crime was being committed. And the crime that was being committed was Miss Abigail Kidder, not Irons. You said Irons. Her last name is Kidder. She likes to text and drive multiple times with her son in the car. So, and he would send me these pictures of his mom, texting and driving. And this is what the issue is that I was having. This is Mrs. Kidder texting and driving multiple times on the highway, wherever, and she's putting my son's life in danger, her life in danger, and other people's life at risk. We have to uphold the law, whether if you work for the law or not. So me calling 911 multiple times, well, only to, report a crime multiple times of her texting and driving. It's against the law. The governor said it. It's part of Michigan law. You're not allowed to have a mobile phone in your hand while operating a vehicle at any point in time, unless you're a school bus driver or some other sort. And she's not. So with that being said, that was the purpose of those phone calls. The only thing I have to say in regards to her stating that Dewan does not get accurate time as like the other children. When I first met Miss Kidder, I had 2 kids already before he was born. And I had custody of a boy and a girl, raising them, working for the schools. Now, my son has autism, and my daughter is cognitive impaired and has autism and ADHD. So at times, as I spoke with Dewan about, there are times that they are in need of a little more attention than him, only due to their disabilities, not their fault. No one's to blame, but at times they are not verbal. They are frustrated. They are complicated, but at the same time, I still manage to parent, never change any judgment or anything on any of my children. I treat them all the same. I have 2 girls. They're both on their periods, Your Honor. I am a father who manages to still be a parent to 2 girls who are on their administration. Like, I'm not a bad parent. I get him to school. I participate in his soccer, his basketball. I have photos to indicate that I'm there at those games. At times, I feel like a lot of this is retaliation, Your Honor, from Mrs. Kidder, due to the fact that we were recently married some odd years ago. And since that divorce, it has never been a point or a time where we came to agreement on anything, only due to the fact that she's mad at me because I left. I can understand that, but I had to leave, Your Honor. It was only in the best interest for me and the children to separate and not be in a toxic situation. So I feel like a lot of these statements are allegations. There's just stuff that has no facts, no grounds, no barriers. There's no burden of proof that I've done any of these things. These are all things that she's stating, but there's no proof to that.
Okay, well, they are allegations, sir. That's fine. That's correct. What I'm going to do in this matter, the court's heard, again, each of the parties. I am going to order a family counseling between the plaintiff and the child, or including the defendant, should the counselor desire to that occur. I will order that the parties would each divide 1/2 of the cost of the counseling, which is not covered by insurance. Court would order that the parties would communicate through our family wizard. That's an app. That's an app that you can put on, and I'll let each of the parties know that as you communicate through our family wizard, the court does have a record of that because they keep an ongoing record of all communications. So the court will, should that be necessary in the future, the court would have the ability to review all of that communication. The court would order that the child would be allowed to have his cell phone while he's in the care of the other party, so he can communicate with both of the parties should he desire to. Court would order that the parties would not discuss the case with the child. That's not appropriate, and that the child's 8 years old. He shouldn't be involved in adult conversations. So court will order that, and the court would order that the plaintiff would not contact the defendant's employer except as he is able to do so by law. With that, Ms. Podolsky, you can prepare an order and submit under 7-day notice of entry.
What can I do, Your Honor?
Thank you.
What do you mean? What do you mean?
Do I have any rights?
What do you mean? What can you do?
Do I have any rights?
Well, yeah, everybody has rights.
Okay, well, why are my rights not being valued right now? Why is it that she texts and driving and breaks the law, and it's your job to uphold her?
Okay, sir, that is not before the court.
It should be because my
Well,
child
it's
is in the
not.
vehicle. My
You
son is in
didn't,
the car.
you didn't bring it before the court, sir. You
So just
brought it
because
up
I
to,
didn't bring it, you doesn't have
stop
to.
talking and listen to what I'm saying. You didn't bring it up. You didn't file any pleadings in this matter referencing that.
I will.
You brought it up today. It's not an issue today. It's not part of the motion for
It's fine.
counseling and other relief. So
It's fine.
well, I guess you want to continue to interrupt. So
I
I
have
will
no
address
right.
it. I will address it if it's properly before the court. It's not properly before the court today, and it's not germane to the issues that were brought before the court. So the court will address those if in fact they're properly brought. So the court will end this matter at 9:14 a.m. You're free to go. Have a good day.
Thank you.
Have a good.
2023 at 9:15 a.m.
Court will note the appearance of Ms. Bendelay on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody and return of child. Ms. Bendelay.
Thank you, Judge. As the court noted, we filed a motion. It was an ex parte motion for temporary custody and return of the minor child. My client filed a complaint with the court in October, I do believe. Essentially, the parties prior to this, they'd been separated for a year. The child at issue is 4 years old. They had worked very well with one another prior to September 11th, which was the premise for this particular motion that we had filed. Essentially, the parties had a, I guess, inconsistent parenting time schedule, but the child was with my client the majority of the time. As I'd indicated, they'd worked relatively well with one another, communicating, indicating when each of them would want the child. On or about September 11th, which was a Monday, my client met Mr. Mays in Bangor, Michigan, for the exchange of the minor child. Previously, both parties had been residents of Van Buren County. In around August, Mr. Mays did in fact move to Battle Creek, Michigan, Calhoun County, obviously. We understand that he moved in with a new significant other, whose address we have as his primary address at this point in time in the city of Battle Creek. So they did the exchange in Bangor, Michigan on September 11th. There, to my client, appeared no issues, no concerns. The transition went as smooth as it typically had in the past. Mr. Mays did in fact take the child at that point in time. On or about September 13th and 14th, which was, I believe, that Wednesday and Thursday, my client tried reaching out to Mr. Mays over the course of those 2 days to facilitate the return of the child. It was her understanding that the child was going to be returned that weekend. So Mr. Mays was basically having the child for the week. Mr. Mays did not, in fact, respond to her. Subsequently, he blocked her on social media, on phone communication, would not answer her calls, would not respond to texts. My client's grandmother also attempted to reach out to him. He subsequently blocked her. And that was the last correspondence that my client has had with Mr. Mays. She's had absolutely no contact with the minor child, even phone calls, since September 11th. My client, frankly, has no idea why Mr. Mays has precluded this contact for nearly 2 months at this point, Your Honor. I understand with our ex parte motion that the court's concern likely would have been the duration and time between the, I guess, separation of the minor child from my client and the motion, which we filed on the 23rd of October. My client filed her complaint initially. Frankly, I would indicate I don't think she was aware of the possibility of an ex parte motion for the return of the child. But, and I'm sure the court has read our motion in its entirety, but my client took several steps in the time between September 11th and her filing in October of the complaint to secure the return of the minor child, or at least to determine her whereabouts. She called the police. I believe the Battle Creek Police Department, or City Police, was her initial correspondence. And essentially what she was informed was that the child wasn't supposed to have known whereabouts, so they couldn't constitute it as a kidnapping. All they knew was that she was supposed to be with the father. I would note that my client had not been provided the address or even the name of Mr. Mays's new girlfriend. She just knew that he was living in Battle Creek. She subsequently determined the address. She was informed by she was informed by a family member of Mr. Mays as to the name of Mr. Mays's new girlfriend. She'd had no contact with her whatsoever. She relayed that information to the police department. I understand a wellness check occurred, was requested. A wellness check was requested on or about the end of September. I understand that the Battle Creek Police went to.
Okay, I don't think this is relevant to the hearing, so it's just extraneous.
Okay,
Get to the
so
point.
essentially, Your Honor, we would just indicate that she made several steps to secure the return of the child. Mr. Mays has not made any sort of communication to her. He's not allowed her contact with the child when in fact she had the child the majority of the time before. We would ask at this point, Your Honor, that the court order the return of the minor child to my client. I understand that the child is currently enrolled into Concha schools. My client enrolled her there following the Mr. Mays's, I guess, refusal to return the child. Previously, the child had been enrolled for preschool at Bangor schools. Mr. Mays, I believe, subsequently tried to enroll the child in Battle Creek schools. We're not sure which school following her enrollment into Concha. We would just ask that the court order the return of the minor child, that the child attend preschool at Concha Public Schools. We had asked for no unsupervised contact with the minor child within our ex parte motion. I believe my client would be amenable to securing a every other weekend parenting time schedule. She does have concerns about the place that Mr. Mays is in fact living at this point. We would ask for no contact with Miss Mays's girlfriend and the minor child if the court's so inclined. We believe, frankly, that the majority of these issues and no contact have been incurred and spurred by the new significant other. We understand that's going to have to be a hurdle that the parties will have to get over, but at this point in time for the interim, we'd ask for no contact, and we would ask for a support order reflecting the parenting time schedule in custody. Thank you, Judge.
Thank you. Mr. Mays, what's your response? You have to unmute, sir.
So there are a few things. One being that the minor child is in fact attending full-time preschool. She is in a very stable environment. As far as the no contact with the significant other, she is a foster parent. She also is a security guard for what she does for employment. Also, I have had her majority of the time. When the mother would visit, it would be sporadic. Sometimes it would go 3 weeks, closer to a month before she would contact saying that she wanted her. There would be other times where she would say that she would want her for a couple of nights and keep her for 2 weeks, give or take. I'd have to say at least within the last 2 months or so, I've noticed through other court hearings that she has had at least 4 different addresses. So I'm just not really sure on what's going on her behalf. But
Okay, tell me what happened prior to the November 11th date. Sound like that the child was going back and forth. What was was there a normal schedule prior to that time?
No, there was not.
Okay. Why, from what you said even, is that the child did go back and forth. So why in the last 2 months approximately has the child not went back to the plaintiff?
So there was a time where she had let her oldest come and stay.
I don't care about the oldest. She's not a part of this action.
So the main thing is the whole school. So she had mentioned it to me that the minor child wanted to go to school. And I enrolled her here. And I mean, it took a while. And then she notified me that, or the mother notified me that she had enrolled her in Van Buren. And it just took off from there.
Okay, that didn't answer my question. I'm saying why in the last 2 months has the child not seen the plaintiff?
Because I have reason to believe that the mother won't return her.
Is that because you didn't return her?
I'm honestly unsure.
Okay. Anything else, sir?
She also has doctor's appointments and dentists scheduled that she is or will be attending, and she wasn't really getting that she wasn't getting the medical attention that she needs.
Okay.
Judge, may I briefly respond?
Yes, go ahead.
Thank you. We would first note as to the Mr. Mays's comments as to doctor's visits. The child had a doctor's appointment in August of this year. My client communicated to Mr. Mays via text message that the child had the doctor's appointment when she was with Mr. Mays. She missed that appointment. My client has enrolled with the children, I guess enrolled, basically issued her at Teconcha's Oaklawn Medical Group. She has a doctor's appointment scheduled on November 22nd. It's our understanding that she is behind on shots at this point. She was supposed to get those shots in August. Frankly, my client contests that she was not getting the child, adequate medical attention. As to schooling, my client had her enrolled at a preschool in Van Buren County. Mr. Mays, to our understanding, did not in fact enroll the child in Battle Creek schools until on or about October 5th, when my client received a call regarding information for enrollment of the child. Mr. Mays had instead represented to my client that he wanted to homeschool the child full-time, to which she did not agree. And at this point in time, we just maintain that Mr. Mays has not presented any legitimate reason as to why the child should be separated from the mother for 2 months, let alone without any contact with the mother for 2 months. We disagree and contest the fact that he's saying that he had the child the majority of the time. My client maintains that she had the child majority of the time. If anything, Your Honor, I think they may have been closer to a joint legal, joint physical custodial arrangement. But again, my client maintains that she did in fact have her the majority of the time. And we would ask for a custody and support and parenting time order reflecting that.
Okay. Well, what the court's going to do in this matter is there is conflicting, obviously, testimony in this case. And as just recently stated, as prior to the November 11th date, the parties did appear to be doing a joint legal, joint physical situation, which was somewhat, I guess you'd say, less than regular, but that they were doing it in some event. What the court's going to do is on a temporary basis, the court's going to grant the parties joint legal and joint physical custody. I'm going to do that in alternating weeks. So the court will order that the child be turned over to the plaintiff this Friday at 6:00 p.m., November 10th, 2023, and she'll have the child for a week, and then the child will go back to the defendant. The court will also order that the parties would alternate legal holidays, and court would order support consistent with the income of the parties, the child support formula, and the joint physical custody scenario.
Your Honor.
Yes.
I request that she stays in her current school if able.
Well, she's in preschool, isn't she?
Yes.
Okay. The court's not going to address the preschool issue at this time. Parties, if the parties can, the child can have the child in a preschool when they're in their respective care. I'm not going to order that now, as the preschool is not mandatory. So that will be the order of the court. Ms. Bendelay, I'll ask that you would prepare an order and submit under 7-day notice of entry.
I will do so.
That will conclude this matter at 9:28 a.m. You're free to go. Have a good day.
Thank you, Judge.
Court will note the appearance of Ms. Huffman on behalf of the plaintiff, Ms. Jensen on behalf of defendant. This matter is before the court on the plaintiff's motion for modification of custody, parenting time support, and show cause. Ms. Huffman.
Thank you. So I had expected Ms. Jansen to not be here, so I kind of prepared a little statement for an adjournment. But in any event,
You're seeking to adjourn your your motion?
No, I don't want to. I just
Oh.
thought that she wasn't going to be here, so
Okay.
I was going to
Well,
indicate that, yeah.
Go
Anyway.
ahead with your motion.
Yeah, so anyway, I just wanted to, I just want the court to, get my client his parenting time back. That's the biggest thing we want. Obviously, we're going to have an evidentiary hearing for the majority of my, motion. So if we could get that set as soon as possible, but, my client, in the meantime, he's being punished. He could go take the child. He could go take the child and bring her home. She's being withheld from him. He does have custody, joint physical custody. But the child is being withheld from him and has been for well over a month now. He could go take this child and bring her up here and not let mom have her back, just like mom is doing, but he's not like that. He doesn't want to take her and necessarily keep her away from her mother. The way
Ms.
mom is
Huffman,
doing.
just before this happened, before the child was retained by the defendant, as you've alleged, what were the parties doing for parenting time?
So mostly, well, even after allegations were made, there was, I don't know if, are we on Zoom right now?
Yes, we are.
So I don't know if the court wants to take us off of Zoom. There was some allegations made that were sexual in nature. And so after those allegations were made, mom continued to bring the child to dad for a week. So my client Alec, he had the child for a week after that. So Monday they had a meeting. Mom was
Has CPS been involved?
CPS was involved. They were informed, right? I believe a week after mom was
Okay,
informed.
let's get to the main point. What did CPS do?
CPS closed the investigation. Mom immediately called CPS again and made another report. CPS is telling my client that they're ready to close that next investigation. They have informed him they have to keep it open for 30 days, but they have found nothing. The police have been over to my client's house because he did go down and pick her up from school on the 16th. He had the child at his house. The police were informed by mom that this child was in grave danger. So the police went out to his house at midnight, had him go wake the child up. This 4-year-old baby goes wake the child up.
Okay, I saw that in your motion. What has happened since the child was retained? What happened before that? What were the parties doing for their
okay, so
time?
before that, they were doing this week on, week off
Alternating
type of thing.
weeks.
Well, it was sort of like that. It wasn't exactly. We put the week on, week off in the order because that was the easiest way to state it. But really, every week my client had the child because mom works. She works late. Dad would have the child until 1 o'clock in the morning or whatever their schedule was. So they had their own schedule. They worked really well together. The child would be picked up at midnight or 1 a.m. or whatever they were doing. But that's just how we put it in the schedule rather than convolute the whole thing. Basically it was 50-50. And so, mom was picking the child up at 1 o'clock in the morning and they were doing the schedule all on their own. They've been doing that for a couple of years.
Okay, let's see what Ms. Jensen has to say. Ms. Jensen, what's your position?
Thank you, Judge. First, Judge, I am asking, I guess, two things. One, yes, I did have another hearing, so I am asking for an adjournment. So I have time to do a written answer and to do the default, set aside the default, file my appearance and everything.
Okay.
Ms. Huffman and I did talk about that, but unfortunately it came to late Friday and we weren't able to come to an agreement. So I have my partner covering something for me real quick so I could be on this.
Okay. Why don't we do this then so we get an answer and then we have better understanding? Why don't we do this is we'll adjourn the matter for 2 weeks, have the matter back at that time, and we'll be able to address everything then.
Okay, Judge, and
Sorry. In the meantime, I would like my client to have parenting time. He's only had 1 day in over a month. I would like him to be able to there's no reason for him not to have parenting time at this time.
Okay.
None.
Ms. Jansen, you started to say something.
Yes, I was also going to indicate that and I can do it with that, but I was also going to, if the court would allow, make a motion for dismissal for lack of jurisdiction, because my client lives in Indiana.
I'm not going to address a motion that's not before the court. So if you want to file your motion, file it, but I'm not going to address it on, sui sponte.
Okay, I will add that with the answer and everything for that to be heard in 2 weeks. With regard to the parenting time, Judge, these are very serious allegations with a little girl.
Well, it sounds like you need to contact CPS. If they're going to close the case, then it obviously is not that serious and considered by CPS at least. So you need to contact them in the interim. And again, if they're going to close the case, then it sounds like the plaintiff should have contact with the child. So you assess it, because the court will take that into consideration when we eventually have a hearing. If the child is being kept from him without any basis, that goes to that particular factor about the willingness to facilitate that relationship. So
if I could just add one more thing regarding, and I know the court doesn't want to address this, but I just want to say for the record, jurisdiction was addressed at one of the hearings.
Bring it up at the time of the motion. We're going to adjourn this, and everybody says we're going to adjourn it, and they keep droning on. So please stop. We'll come back in 2 weeks when everything's before the court, and we'll address everything at that time. Court will end this matter at 9:37 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Ellsworth on behalf of the defendant. Go ahead, Mr. Ellsworth.
Thank you, Your Honor. Your Honor, we have not been able to serve the plaintiff in this matter. We tried to get a good address for her. We reached out to the friend of the court. We received a denial request from the friend of the court based upon her confidential address. So we're having a hard time serving her.
Okay, there is a way, if you look at the court rule, when there's a confidential address, there's a way for you to provide that, the pleadings to the clerk, and then they will make sure that those get served. So that's all I can address you to is the court rule that shows how to service is accomplished. And then you'll have to renotice it.
Very well, Your Honor, and I will do that.
Okay, thank you.
Thank you.
Court will note the appearance of Ms. Reed on behalf of the plaintiff, Mr. Fernandez on behalf of defendant. This matter is before the court on the plaintiff's motion to show cause to enroll the child in Sunset Lake. Ms. Reed.
Thank you, Your Honor. We did have a brief case history in our motion, but the main issues are we have 3 orders that direct the parties to use Our Family Wizard, and the defendant has failed to do that. It does not take over a year to enroll or figure out any issues that he's having with Our Family Wizard. Those same 3 orders direct the parties to participate in co-parenting counseling, and it does not take the defendant over a year to contact the co-parenting counselor, and the last of those orders gave him until the beginning of October to contact Ms. Katz specifically, and we did not receive a response in the defendant's response to if he's actually done that. The last time I spoke with Ms. Katz, he had not done that yet, and then since entry of the last order in the beginning of October, he has denied my client all of her parenting time. Right now that's at 5 days of Wednesdays after school until about 7 or 8 o'clock, and then 3 days of weekend overnight parenting time. And we have a running history of whenever my client gets any sort of parenting time, we have falsehood-laden ex partes filed to try to suspend her parenting time, followed by extended periods of parenting time denial. He is not willing to facilitate a relationship with my client and the child. And then we have the last issue, which the child had been enrolled in Sunset Lake Elementary School. My client went to the school to pick the child up for her Wednesday parenting time and to contact the school regarding some school records and attendance issues. And the defendant made the unilateral decision to remove the child from that school, and that's a joint legal custody decision issue, which he's completely excluded her from. We have no idea where she's enrolled or if she's enrolled, and we're constantly having these issues. She's wanting parenting time. She's trying to exercise her parenting time. He refuses to communicate with her. He refuses to sign up for Our Family Wizard. He refuses to go to co-parenting counseling, and he refuses to follow the orders regarding parenting time. So we're asking that he be held in contempt of court, that the child be re-enrolled into Sunset Lake Elementary, where she has been attending for the last couple of years. We're requesting makeup, parenting time, and attorney's fees.
Okay, thank you. Mr. Fernandez, your response.
Yes, Your Honor. So shortly, I believe before this show cause, we filed a ex parte to suspend parenting time. That was denied based on the fact that our client received a voicemail from the child saying that she was being beaten and trapped in a closet. And so we still want to have an evidentiary hearing on that issue as well. And I believe that would show good cause for the reason for the denied parenting time. In addition to the voicemail, we have witnesses who could also prove that that abuse did take place. So, and the reason for the change in schools beyond.
Did your client contact CPS?
I know the police were contacted. I'm not sure if CPS were aware or not.
Okay, go ahead.
And the reason that he changed the schools was because this case does have a long history of Ms. Eguia and her father threatening our client. So he was forced to move from his home based on threats of a possible shooting. And once he moved, then he re-enrolled the child in a new school closer to him. So we would ask that both of these issues be heard on the same day, Your Honor.
Okay. Well, obviously there's a dispute. The court will set the matter for an evidentiary hearing, but in the interim, until we get something else, and in the interim, the plaintiff is entitled to her parenting time, and the court would order that the child would go back to the Sunset Lake Elementary School, again, until we have an evidentiary hearing and we can, again, figure everything out at that time. So,
okay.
Ms. Reed, I'll let you do the order on the, at least on the interim, and we'll set the matter for evidentiary hearing.
Okay.
And we'll be in touch with both your offices and find out when you're available to do that.
Is the court reserving on attorney's fees for now?
Yes, I'll reserve on everything else.
Okay.
Pending that evidentiary hearing. Okay. Thank you. Court won this matter at 9:45
Shelby Platypus versus Corey Warner. Today is Monday, November 6, 2023 at 10:29 a.m.
Good morning to all of you. Court will note that this matter was adjourned from 2 weeks ago to allow the plaintiff to get representation. She has. Ms. Moss has filed an appearance on behalf of Legal Services. The matter is before the court on the defendant's motion for dismissal for lack of subject matter jurisdiction and for dismissal of default in this matter. I do note that the plaintiff again has filed their response and has stated that the court should contact the Alabama court pursuant to Michigan compiled laws 722.1206 parens 2, and the court would note as well pursuant to 722.1204 parens 2 as it relates to temporary emergency jurisdiction. So I guess that's at least your request, Ms. Moss, in this matter, that the court do that, and I guess that's preliminary to anything else.
Yes, Your Honor, and I'll just note that, yeah.
Okay. You understand, Mr. Warner, what they're asking is that, again, under the statute, the court, when it's requested, the court's required to communicate with the other court to see who wants to take jurisdiction in the matter.
Yes, I understand.
Okay. I do want to correct, I guess, either Ms. Redmond or Ms. Moss. A couple things, though, as I note as I'm reading your answer and reading the motions. Do you, in fact, acknowledge that Alabama is, in fact, the home state of the minor child?
Yes, we do.
Okay. And again, that the plaintiff did file for custody in Michigan on or about July 14, 2023.
Yes, Your Honor.
Okay, I just wanted to clarify that, so when I talk to the Alabama judge that we have, again, those facts in place. So what we're gonna do is I will adjourn this matter without date. I will make communication with the Alabama judge, and then what we'll do is contact you at that point, and we'll probably come in for a status conference in which we'll address the motion at that time after I had a chance to speak to the other judge. Okay?
Okay.
Anything else, Mr. Warner?
Yes, Your Honor. From my understanding of emergency jurisdiction, that'd be for the plaintiff or the defendant, whoever's filing in that state, would be so they could get temporary jurisdictions to get sole custody. Shelby and I was never married, so I don't really feel like it's necessary because automatically has sole custody.
Okay, well, temporary emergency jurisdiction doesn't just simply isn't confined just to that. Okay. In fact, I will read particularly so that you have that from the statute. Okay, it says here that and this is this 722.1204 states that a court of this state has temporary emergency jurisdiction if the child is present in this state and the child has been abandoned, or it is necessary in an emergency to protect the child because the child or a sibling or parent of the child is subjected to threatened or mistreatment or abuse. And that is the basis on which they're stating temporary emergency jurisdiction. If you read their answer, you'll see that they have alleged that abuse and violence in this particular matter. So the court is on that basis is going to obviously communicate with the Alabama court, and as stated under 722.1206, obviously the court would not exercise jurisdiction if another action has been commenced in the other court. And so I know that you filed an action in the other court that the defendant has also filed in Michigan. So that is why the court at least needs to communicate with Alabama to get those issues resolved. So that's what I'll do. We'll have you back in for a status conference, at which time the court will address again the determination between this court and the Alabama court. Okay. Thank you all. We'll end at 10:34 a.m. You're free to go. Have a good day.
Defendant is not here, but Attorney Robinson represents him. So
okay. Good afternoon to both of you. I'll start with you, Ms. Kulikowski, just so that as you are the plaintiff, and enlighten me what's happening in your case.
Happening as far as like the kids and
Nope. What's happening? Have you mediated? Where's the case at? What have you done? Have you come to resolution? What?
no, we haven't mediated because I can't financially afford it. And we haven't really resolved anything at all.
Okay. Mr. Robinson, does that seem to be the scenario?
It is, Your Honor. According to John Brundage, he said the plaintiff said she couldn't afford it and she wasn't going to agree to anything anyway in mediation. So
okay.
I did not say I wouldn't agree.
File.
Sorry.
Well, it sounds like we have to set this matter for trial then. So
okay.
What we'll do is we'll be in touch with both of you and see that your schedules are open, and we'll set it for trial, and then we'll proceed in that manner.
Thank you.
Okay.
now, should we set it for 1 or 2 days?
Well, I don't have.
I would say no more than 1 day.
Okay. Do you have any idea, Ms. Kulikowski?
No, 1 day's fine.
we'll set it for one day and then we'll decide at that point as to what we need to do.
Okay,
Thank you, Your
Okay.
Honor.
Thank you. Have a good day.
you too.
Good afternoon to both of you. Court will note that this matter is before the court for a settlement conference, so I'll go to Ms. Hilario Ortiz first, as she's the plaintiff. Ms. Hilario Ortiz, tell me what's happening in your case.
We did not come to an agreement, so I would like to request a bench trial.
Well, that's what you'll get. You don't get a jury trial in these cases, so that's what you'll get.
Okay.
Mr. Bishop, is that your understanding as well? You didn't come to an agreement?
Correct, Your Honor.
Okay. And just enlighten me or remind me, what are the issues that are in dispute at this point? Go ahead, Ms. Ortiz.
I'm requesting custody, parenting time, custody order.
Okay. So custody, parenting time, and child support, is that the issues?
Yep.
Okay. Mr. Bishop, is that your understanding?
Yes, it is.
Okay. Well, what I'll do is we'll be in touch with you. I'll have my office contact you. We'll set a trial date. We'll set it for one day. We start at 8:30. We start promptly. So make sure that you are ready and able and available at 8:30 on the day that we set it for, because we do want to get it done in one day then. So we will we'll set the date after we talk to you, and then we'll get together on that date and try the case.
Okay.
Will that be, Your Honor?
What?
Will that be via Zoom?
Yes, it will be by Zoom. I will need to, how old is the child?
6.
Okay, I'll need to speak to the child on that date. So, 'cause I do have to interview the child.
She is verbal, but she's not, like, she can't make a full sentence all the way. She might not understand.
Okay, well, regardless, I'm required to interview her. We'll do that. What I'll do is we'll start at 8:30. I'll say, plan on having her at the courthouse at 8:15, and I have a third party bring her so that we can start at 8:30. So I don't know if you have some relative, friend, whatever, that could bring her to court. We'll interview her at 8:15, and then we'll go right into the trial at 8:30.
Okay.
Okay. Any questions, Ms. Hilario Ortiz?
Not at this moment.
Okay, Mr. Bishop?
No, sir.
Okay, we'll be in touch with you maybe later today or probably tomorrow and set up a trial date.
Anywhere about how far out we are, Your Honor?
No, I don't have any idea on the schedule. No.
Okay, thank you.
Okay, thank you.
1:52 p.m.
Free to
Plaintiff
go.
is not here, and we have reset this matter from October 2nd. The parties settle at mediation in September, but we had decided that if the plaintiff didn't appear again, that we would dismiss the case. So that's where we are.
Okay. Mr. McClellan, I'll ask you, because you have appeared at both of the settlement conferences. We stated last time if she didn't appear, we'd dismiss it. Is that what you would like us to do, is dismiss the case?
Yeah, you can go ahead and dismiss it.
Okay, well, I don't want to. If you want, you can complete it as the defendant. But you'd have to prepare all the paperwork to complete it.
Yeah, it's fine. We got a pretty good schedule and everything been going smooth, so.
Okay. What happens, the court will dismiss the case then as a result of the failure, again, of the plaintiff to appear. She failed to appear on October 2nd, 2023, and now today on November 6th. And the defendant is, again, it's acceptable to defendant to dismiss the matter, so we will do that. Okay? Thank you, sir. You don't have to appear at anything in the future then, and you have a good day.
Thank you.